the case that could end permits nationwide. This isn't a drill. The United States Supreme Court just took an emergency step that no one saw coming. And if things go the way many experts expect, this case could strike down permit-based concealed carry laws nationwide. The lawsuit is called Woolford versus Lopez. It comes from Hawaii, but its impact could be national, because the Supreme Court is no longer waiting for lower courts to fix broken gun laws. They are stepping in directly. This case challenges Hawaii's ban on carrying firearms in public spaces without explicit permission. It's a direct clash with the Second Amendment and the court's own precedent in Bruen. So, if you carry, if you value your right to self-defense, and if you believe in the Constitution as it was written, you need to understand what this means. Subscribe to Survival Firearms, because this case could change the future of gun rights in every state, and it starts right now. Chapter 1. The Supreme Court makes a rare move. The Supreme Court rarely steps in at this stage of a case. Normally, it waits until full trials are finished and all appeals have played out. But with Woolford v. Lopez, the justices broke their own tradition. They granted review immediately before the case even reached a final ruling. The case is still at the preliminary injunction stage. An emergency review was granted despite no final judgment from the Ninth Circuit. This signals that the court sees an urgent constitutional problem. The justices may use this case to reinforce or expand the Bruen precedent. This rare move shows that the court is no longer willing to sit back and watch lower courts undermine the Second Amendment. The issue is too serious and the consequences too broad. By stepping in early, the court is preparing to set a national standard again. Chapter 2. Hawaii's concealed. Carry ban goes too far. After Bruen, many states tried to push the limits of what restrictions they could keep. Hawaii went further than most by flipping the assumption of legality. Their law treats public-facing private property as off-limits by default. Only explicit permission makes carrying legal, even with a permit. All public access private property is treated as a gun-free zone by default. You can only carry if the property owner posts a sign or gives verbal consent. The law assumes criminality, reversing centuries of American legal tradition. Even permit holders are treated as unauthorized unless they prove otherwise. The district court saw this as unconstitutional and blocked the law temporarily, but the Ninth Circuit reversed that ruling, allowing the ban to take effect again. That decision sparked the emergency appeal to the Supreme Court, and the battle began. Chapter 3. The DOJ Surprises Everyone. In a highly unusual move, the Department of Justice sided with gun owners. They filed a brief arguing that Hawaii's law went too far, even by the government's own standards. The DOJ stated that the ban was not consistent with the Second Amendment or with the court's own decision in Bruen. This shift in position was unexpected and had a big impact on the case. The DOJ said Hawaii's law undermines the right to carry for self-defense. They warned that public carry cannot be outlawed by default. The brief recognized that law-abiding citizens must be allowed to carry in most public spaces. This bipartisan support gave the plaintiffs a major legal advantage. The DOJ's involvement stripped Hawaii of its usual defense. When the federal government refuses to back your law, it weakens your case. And in this instance, it helped push the Supreme Court toward taking action. Chapter 4. Conflicting rulings force the court's hand. One major reason the court accepted the case is because of disagreement among federal courts. The Third Circuit and the Ninth Circuit have now issued rulings that directly conflict. That kind of legal contradiction demands Supreme Court resolution. Without it, rights change depending on where you live. The Ninth Circuit upheld Hawaii's carry restrictions. The Third Circuit rejected similar rules as unconstitutional. This creates a circuit split affecting millions of Americans. The court must now decide which interpretation is correct. This type of divide cannot last. The Constitution cannot mean one thing in California and something else in Pennsylvania. By granting review, the court is stepping in to restore national consistency. Chapter 5. Hawaii's legal strategy collapses. At first, Hawaii asked the court to delay the case. They argued that more evidence was needed at trial and that it was too early to decide. But the state's own past statements came back to haunt them. They had already told the Ninth Circuit that nothing more needed to be developed. Hawaii's lawyers admitted it was purely a constitutional issue. They told judges that no additional facts or hearings were necessary. Their new argument contradicted their earlier claims in the same case. The court took note of this and saw through the delay tactic. This contradiction damaged Hawaii's credibility at the highest level. Their changing positions helped justify the emergency review. Now, with the spotlight on them, the state may be facing a broad and lasting defeat. Chapter 6. The Private Property Trap. The heart of this case is Hawaii's decision to flip the burden of proof. Instead of citizens having the right to carry unless told otherwise, the state assumes carry is banned everywhere. Only if a property owner posts a sign or gives verbal permission can you legally carry. This is not just legally backwards, it's historically unsupported. The law treats all public access private property as off-limits by default. Gun owners must obtain express permission before carrying anywhere open to the public. The district court said this inversion had no historical precedent. Bruen makes clear that rights cannot be conditioned on assumptions of criminality. This legal trick isn't limited to Hawaii. Other states are watching, ready to copy it. If the court doesn't strike it down now, it becomes the next big loophole in gun rights nationwide. Chapter 7. The Bruen decision returns. Everything in this case ties back to Bruen, the 2022 ruling that changed the Second Amendment landscape. Bruen said that gun laws must align with historical tradition, not modern preferences. It rejected the idea that states can balance rights against their own idea of safety. Now, the court will revisit that exact standard and possibly expand on it. The Supreme Court will reassess how lower courts are applying Bruen. Text, history, and tradition remain the guiding texts. Any law with no historical roots is presumed unconstitutional. The Wolford case may force the court to clarify how far Bruen goes. This isn't just a ruling on one law. It's a chance to reinforce the original intent of the Second Amendment. And it's a warning to lower courts that tried to water down Bruen. Chapter 8. Lower courts and the crosshairs. One of the unspoken goals of this case is to rein in the lower courts. Since Bruen, many judges have openly defied the standard, using modern tests to justify new restrictions. Hawaii's victory in the Ninth Circuit is one example. Now, the Supreme Court may be preparing to send a message. The Ninth Circuit's decision upheld a near-total carry ban. That decision directly conflicts with both Bruen and the Third Circuit. The Supreme Court can now re-establish authority over the lower courts. The ruling may include language aimed at discouraging future defiance. If the justices choose strong language, it could reset how courts interpret Second Amendment cases, and it would make it harder for activist judges to bend the rules in the future. Chapter 9. What this means for gun owners. This case is about Hawaii, but its impact could stretch across all 50 states. If the court rules broadly, states that rely on permits and restricted carry zones could lose those powers. It could transform concealed carry into a truly national right, not a patchwork of inconsistent policies. That includes states like New York, California, New Jersey, and Maryland. May issue permit systems could collapse under this ruling. Property default bans may be ruled unconstitutional. Gun owners could gain stronger protections for public carry. The court may create a precedent for striking similar laws in the future. This isn't just legal theory, it's a direct threat to the gun control framework in multiple states, and it's the most significant carry rights case since Bruen itself. Chapter 10. What comes next? Now that the Supreme Court has agreed to review Wolford v. Lopez, the legal clock is ticking. Briefings will begin, oral arguments will follow, and a ruling could come within months. In the meantime, states are watching closely to prepare for impact. Some will double down on restrictions. Others may start rewriting their laws in advance. The Supreme Court limited its review to one specific question about carrying on private property. That focused review allows the justices to issue a sharp, narrow opinion. If they rule in favor of the plaintiffs, similar laws in other states will fall. Gun rights groups are mobilizing to file supporting briefs and legal challenges. This could be a turning point in the national debate on gun rights, and how the court rules may determine whether states can ever again default to banning carry by assumption. The next battle begins now. The Supreme Court just took a stand, and it's a shot across the bow. Wolford v. Lopez isn't just a case about Hawaii, it's about the future of the Second Amendment across America. And the next ruling could end permit-based carry as we know it. At Survival Firearms, we'll keep you ahead of every legal move. So hit that subscribe button, share this video, and stay informed. Because the fight for your rights isn't over, it's just getting started. Stay trained, stay ready, and most of all, stay free.